Hey everyone, Shawn McBride with you. Welcome to another edition of the McBride Attorneys Law Show. Today we're going to be looking at 5 common mistakes that we see in form documents. So in this video we'll be jumping into stuff I've seen over the years. A lot of clients use form documents, come to me after the fact, after they've already had a problem, the other side's not doing what they want to do, or they're starting to get into an issue and they say, here, Shawn, my attorney, can you take a look at this and help me out? And sometimes there's unfortunate provisions in there, which if they hadn't been in there the first time, we'd be in a lot better legal position. So today, we're going to look at 5 common mistakes that people make in their documents. Quick note, as always, I am an attorney. I'm not your attorney by virtue of doing this video. We're not forming an attorney-client relationship. Go consult your attorney, but this will give you things to think about as you're working through things when you're talking to your lawyer. All right, so what are these common mistakes? Number 1, acceleration clause. So a lot of times you'll have contracts and agreements where you have periodic payments over time. And one thing we'll see in good, well-drafted agreements where you have a lawyer involved, where you're using sophisticated forms, is you'll have what we call an acceleration clause. And the clause will basically say, if one party, usually the party who is receiving the services, etc., if they don't make their periodic payments, that the other party can declare the entire amount due. So what will often happen is, for instance, a loan is a very common thing. This might be a loan from a business sale, might be a mortgage, other document. It will say, if you stop making those periodic payments to me, the lender, I will be able to declare the full amount due. And this seems like a very harsh provision, but it's very necessary in the event of litigation, because otherwise all you're due is those periodic payments, which means in case of a mortgage, we think of a 30-year house mortgage or maybe a 10-year business sale, you might have a stream of 100 plus payments. If you don't have an acceleration clause, you have to wait for each payment to come up before you can file suit. So you might end up having to file 100 lawsuits, and you can imagine the administrative inconvenience, or you'll have to keep amending your suit every time a payment comes due while the suit is pending. So it can be a real logistical challenge. So if we see loans in there, if we're on the lender side, we typically want to make sure acceleration clause is in there. I've had this problem pop up in practice. Clients did a business sale, looked at a form document. They didn't update it from a one-time cash sale, which is very common in business sale, to a periodic installment payment. When they did that on their own and didn't consult me, they only came to me later, they didn't put the acceleration provision in there. So unfortunately, we couldn't ask for all the money. We can only ask for parts of the money. Real tough situation. Number 2, common mistake is not having a buy-sell provision or a breakup provision. So a lot of times in business, right, we have to contemplate the fact that we may not be doing business together forever. And so in LLC agreements, where I spend a lot of my time, I do a lot of partnership formation in my legal practice, we have to have a buy-sell provision, right? What if one buys out the other, particularly in a 50-50 partnership? Because if 2 50-50 partners can't agree, we have a stalemate, business can't do anything. And the business could spend so much time going sideways. We've actually seen businesses go out of business because the partners are fighting, can't pay the lease, you can't get money into the checking account. It can be a whole host of problems. So we really want to avoid that. We want to have a buy-sell provision. Similarly, in a contract, we want to have some type of breakup provision, right? So what does it look like if we need to break the contract? Do we go to arbitration? Do we go to litigation? Are there liquidated damages? Liquidated damages being a fancy term for just saying, hey, we're going to say you owe me this much if you break the contract, rather than have to calculate damages, which can be a whole phase of litigation, right? If you get multiple parties, one doesn't do what they want to do. Basically, the concept is in contract law, the court's supposed to put people back to where they were if the contract had been performed. And as you can imagine, you're trying to imagine what the future would look like, calculate the financial effect of that, work backwards to the day, get financial numbers. Can be very complicated to calculate damages, so liquidated damages. But the overall concept is, let's have some type of provision where we say, hey, if one of us needs to buy out the other, what does that look like? Another common mistake, this is a third common mistake for you, is not having the right parties to the contract. And this sounds simple, but when we start getting business entities involved, it can become very complex, right? Working through, a recent transaction, we have the client, we have the company that the client purchased from, and that company was run by an individual who owned some property in their name. They also had a leasing company they had set up for tax purposes, and the core company, right? So now my client in this acquisition is dealing with three different parties, right? So we need to be very careful to parse who's signing what in what capacity. And a lot of people make a mistake, particularly with LLCs. They don't sign the signature line right. They have the parties wrong. They name the person instead of the LLC. They name the LLC instead of the person. A lot of times the LLCs don't have a lot of assets. You want a personal guarantee, something you can go after if the deal goes wrong. So there are a lot of things to bake in there about who are the right parties to this agreement. So we need to stop, pause, examine the entire situation, and think about who the parties are to the contract, what that looks like, and make sure we name the right parties in the contract itself. Number four big mistake is we don't get the right phrases in there. So generally in the law, particularly now in modern times, the concept is to have a clear understanding. Plain English is a term you'll hear a lot, and I think it's a great way to draft a contract. But there are certain concepts and certain things that need to go into contract a certain way, almost magic phrases. And they're rare, but they exist. And sometimes you just need to have a particular phrase a particular way. For instance, let's say you have a company and you're setting it up and you're going to put money into the company, a capital contribution. You're going to build this into your LLC agreement. In that capital contribution provision, what we as lawyers like to see is a cap on capital contributions, right? You will contribute this money up to this level. What I've seen people do in unfortunate circumstances where they don't have the right phrasing in that section is they say, the owner's obligated to contribute money to the LLC. Well, if you don't have a cap on it, a maximum amount, that becomes an unlimited amount. And this can become a real problem if you have a creditor situation, because without a cap on the capital contribution, that creditor could potentially ask you to keep putting more and more and more money in it. So right there, by having the wrong phrasing, you could actually circumvent all the limited liability protection that you're building into the LLC agreement. So small thing, big consequence. Really got to make sure you get that right. So make sure you have the right phrasing in there for your situation. And you got to look at a lot of contracts. You got to understand the cases around it, understand what the courts have really fought on, and make sure you have that right phrasing so that you don't end up with these unexpected situations, because I see a lot of times contracts have that. Number five, big mistake, sometimes people are missing entire documents. I see this in a lot of transactions where people copy and paste forms. They may copy and paste great forms. They may buy great forms on the internet, but they miss entire documents. Comes up a lot with corporations. People will come to me and say, hey, will you represent my company? We're going to do this acquisition, or we're going to sell to somebody else. And I say, great. Give me your corporate documents. And I'll get from them the certificate of incorporation they file with the state. And I'll say, great. And, of course, this varies a little from state to state, but basically usually the same. Usually there's a whole suite of other documents to go with that, right? You have the corporation certificate of incorporation, you have the bylaws, you have stock purchase agreement for the initial sale of stock, you have some board authorizations going on there, you have an incorporator consent. So LLC usually is a much smaller set of documents. A corporation, you got a whole suite of documents that flow. And I see people miss the entire set of documents when they're filing a corporation. They might get one or two of the documents right, get the certificate of incorporation, get the bylaws, but they forget to issue the share certificates, or they forget to have the incorporator consent. So you really want to make sure you get a good checklist of everything you need if you're doing a transaction on your own to make sure you're not missing something. So I hope that's helpful. Let's summarize again. Number one missing thing is acceleration clause. Number two is buy sells. Number three is getting the right parties to the contract in the right order. Number four is the right phrases. Number five, make sure you have the right documents. All right, folks, drop your comments. McBride Attorneys Law Show on YouTube. Subscribe for more stuff that's going to help you as a business owner and business leader. And I, of course, look forward to seeing your comments. Tell me what you think. Tell me your experience on this. Tell me what you're doing next. But don't include any confidential or attorney-client information in the box. All right, looking forward to seeing your comments on YouTube.